Yeah, the webinar's now live. So people are starting to come in. Good afternoon, everyone, those of you that are joining. I think we've got around 90 participants this afternoon, so I'm going to wait until those numbers will get up nearer to the 90 mark, and then we'll kick off. Good afternoon, everyone. I'm just waiting for a few more people to join. I think we've got around 90 today, and there's a few people in time, so just give it another couple of minutes before we kick off. Okay, it's 4 o'clock, so I think, Sean and Jenny, I'm going to start and open up the seminar this afternoon. Well, thank you to everyone that has signed up and joined in the seminar this afternoon. The session this afternoon is on delay, and as those of us that work in the construction industry know, delay on construction projects occur regularly and few complete on time. Never has this been more evident than over the last few months as employers, contractors and their supply chain have had to grapple with the effects of the COVID pandemic on live projects. But delays can occur for a multitude of reasons on construction projects, and the question of what and who caused the delay and what remedies may be available to the parties if delay occurs can be a cause of complex disputes between the parties and involve detailed delay analysis. This afternoon, to help guide us through this complex area of law, I'm very pleased to present two eminent speakers from Four Pump Court who will be discussing delay claims and providing a guide to dealing with delay on construction projects. Firstly, we have Sean Brannigan QC, who's Joint Head of Chambers, and with him today is Jennie Gillies, who's a senior junior. Jennie has spent time in-house as well as at the bar. Sean and Jennie regularly work together as a team on disputes. Sean has acted on a number of key cases which have forged the now fairly well-established position in English law on delay, including Walter Lilly and Cyden Homes, and is therefore able to give us some insight both in terms of what was reflected in those judgments, together with discussions of the Court of Appeal Tribunal, which are not reflected in the judgments. Sean and Jennie also both have experience of working outside the jurisdiction. Sean's regularly instructed on international arbitrations, and Jennie spent 2 years as head of global disputes with Arup before coming back to the bar. We therefore have two specialists with us today that can help provide insight into similarities and differences between delay disputes in our and other jurisdictions and how they're dealt with by other tribunals. So just as a final point before I hand over, obviously this afternoon we only have 45 minutes to discuss these issues. So today Sean and Jennie will be providing a high-level guide and some useful pointers. So we tend to close the seminar at 4:45 and then open the floor for questions. If you do have any questions, please use the chat facility and I'll keep an eye on those coming in. So without further ado, I'll hand over to Sean. Thank you.
Thank you very much, Justine. And thank you very much to Spencer West for hosting us. It's a pleasure to be here. Here being a relative term, as I sit in my office at home with towers of paper around me that you can't see because I've cleared them up just to go on a Zoom call. Very welcome to everybody. There's even some people from Belfast, some familiar names to me. It's seeming to be the one place that's worse hit than Manchester in the whole of the UK. So congratulations to everybody from Belfast who's made it through to the seminar. I'm in control of share screen today in order to deal with the slides, which is always a recipe for disaster. So if my emails pop up halfway through, despite turning them off 3 times, that's completely my fault and nobody else's. Let me tell you what we're going to talk about. We're going to deal with the 6 topics you have in front of you, and we're going to go through them one by one. And as Justine's already said, we're going to speak for about 40-45 minutes to leave 15-20 minutes for questions, because I think Jenny and I both recognise that often the question and answer session is the bit that people really want, because that's where they get free advice, subject to deep disclaimers and caveats from Jenny and me. Justine will keep an eye on the questions, and Justine, if there's any question that you want to interrupt with halfway through the thing, just shout. Basically, you don't need to wait to the end if there's some particular point which has emerged through it. I'm conscious, because Justine has shown me the list for today, that there's kind of a range of people's knowledge and perception when it comes to delay claims. We've got some very esteemed mediators, we've got some very experienced solicitors, we've got some people who are mostly site-based, and we've got various experts in various fields. So there's definitely a range of experience, I think, and I'm going to try and pitch this along with Jenny, so there's something for everybody at somewhere along that range. I'm going to try and do that by kind of building up relatively slowly, going back to first principles. Not, I hope, to teach people to suck eggs, but because I often find it's quite useful whenever you're dealing with something like delay, just to stand back and to think, well, what is all this about? Rather than start at the end where you're opening up Gantt charts and Primavera programs and thinking this is all a bit of a mystery. It's not that mysterious, I think, whenever you start from the start. So, what's the point of a delay claim? The point of a delay claim starts from the premise that Justine said, that in every project that's ever been started and finished, from the pyramids upwards, there is extensive delays. And those delays have to be paid for by somebody. The delays are often an unwelcome result of a project to both employer and contractor, and somebody has to pay for it. To that end, contracts often contain pretty elaborate sets of clauses that deal with the consequences of something going wrong and causing delay to an activity. From the employer side, very often they make sure they insert some clauses that say if the contractor finishes works late, the employer shall get liquidated and ascertained damages, or sometimes called liquidated damages, which is a set sum that's payable per day or per week or per month for every time period that the project's in delay. And so from an employer's perspective, if the starting point is if a project is finished late, he gets damages from the contractor. From the contractor's perspective, is that if there's delay which is not his fault, he's going to want to put in a claim to get the time for doing his works to be extended, the well-known phrase extensions of time, and that means that the liquidated damages kick in later in the piece. So if the contractor is supposed to finish on the 1st of January and something bad happens, he might be able to get an extension of time to the 1st of February and miss out the first month of those liquidated damages. But of course, that's not all a contractor wants to do. In addition to not paying damages to the employer, often a contractor is going to want to receive money from the employer, what's called loss and expense, because somebody has to pay for all of this. Construction lawyers are kind of conditioned from birth to think of time and money being two very divisible, very different things, and they obviously are. It's possible for works to be late and for it to end up that the contract doesn't really deal with it and the consequences of it are just felt by both sides. But more often than not, time does mean money in the construction trade. And it's often really important from a contractor's perspective to not only get relief from liquidated damages to pay to the employer, but to get the employer to pay him for being on site longer. And that's where these disputes often arise. So on a very basic level, you have two sorts of events which are dealt with in the contract. An employer delay event where the employer holds up the contractor, and that tends to be things like the employer giving over the site late to the contractor, changing the works quite late in the piece, which causes a delay to the works. Sometimes bad weather if the employer takes the risk of that. Typical things where the contractor causes delay, a contractor delay event, would be things like a subcontractor not turning up to do the work, or running out of materials, or running out of equipment, or just things going more slowly than the contractor would have hoped for. Particularly in a situation where a contractor may well have taken a very optimistic view as to how long the works were going to take when putting in their bid for the project to win the project. And sometimes at its most charitable, those views are so optimistic that absolutely everything has to go right to make it work. But it's not often everything does go right in life. And at the less charitable, it's quite often when you come in to look at these disputes, it becomes apparent pretty quickly that the works were never capable of being done in the time the contractor said. And there was always a dispute baked in that was always going to happen. So in terms of looking at the building blocks, sort of looking at the next level of first principles of this for extensions of time, it's important to recognize that none of this exists in the vacuum. And the reason I say that is it's sometimes surprising how often you're brought in to have a look at a dispute, and what a contractor will say or an employer will say is, there is no way we can be responsible for paying for this dispute. It just isn't fair. Obviously, the pandemic we're currently living through and the consequences of that being one of the most obvious examples of that. But there's loads of other examples. There's loads of things that happen on a site whenever one or other party can have a view quite honestly and perfectly rightly that it's not morally right, they're responsible for it. But the starting point is always what's morally right is what the parties have agreed up front. And most modern contracts go out of their way to agree what's called a series generally of relevant events, things which do give rise to an extension of time. And it's quite important here to bear in mind something which is often overlooked, which is this whole complex system of having a series of events which, if they happen, can give rise to an extension of time, which in turn can push out the date in which liquidated damages are charged. Sometimes people think that's for the benefit of the contractor, and it really isn't. The starting point of all of this is a series of cases that go back for before I was born, and that was a while ago, which effectively say that it's absolutely right that if a contractor agrees to do work within a certain period of time, she has to do it within that period of time. But if the employer prevents the contractor from doing the work within that period of time, the employer can't complain about that. The date goes, and the employer can't charge any damages for that. And all that's left then is a general obligation to complete the works within a reasonable period of time. And that's what's sometimes called an active prevention by the employer. So the point of an extension of time clause that says if X or Y happens, the time for doing the works can be extended, and then liquidated damages kicks in after that extended date, isn't for the contractor at all. It's to protect the employer against doing something wrong, that not being covered by the contract, and the contractor being able to say, well, I've been prevented from doing my works, so time's at large and so on. And that's quite important. And again, it's surprising, despite that, being in sort of chapter 1 of Keating and chapter 1 of Hudson and building contracts, it's surprising how often that's overlooked whenever people are coming and construing those clauses. So it's important to recognize that. At kind of the next level up of looking at this and asking yourself, well, how do you build up a delay claim? And is there kind of a dark art to it? I don't really think there is. I think there is a clear and obvious way to build up a delay claim. And often it is precisely the opposite of how people go about building up a delay claim. The way not to do it is to get a delay expert, bring them in, say, do me a fancy report, and having got that, then present this fancy report with lots of graphs, lots of pretty pictures, and saying, there we go, there's my delay claim. Because 25 years ago, I think that worked because computers were new and color printers were new, and everybody thought this was deeply impressive. But most sensible adjudicators realize now that the report that's produced can be, and often is, utter nonsense, not reflective of reality at all. The only way to build up a delay claim to have it work is to use what I would call a pyramid model, with the bottom layer of the pyramid being the most important. The bottom layer of the pyramid of the documents is what the documents show happened on site. The next layer up is witness evidence, people who were there. But it's a proper pyramid structure in terms of importance, with the bottom layer being the most important. Because all the witness evidence in the world's not going to help if the documents tell a completely different story. It is possible for witnesses to be able to explain away one or two or three or four errant documents. Yes, the minutes say that, and yes, I should have corrected that, but I didn't notice it. Or yes, that letter says that, and perhaps I should have responded to the letter, but I was too busy getting on with the works. But no witness can explain away all the minutes telling the same story, or most of the minutes telling the same story, or most of the documents. And much as a barrister can sit and thump the table in a conference and say to you, don't worry, we'll be able to overcome this, I'm such a brilliant cross-examiner, it's nonsense. People aren't stupid. A sensible judge, a sensible arbitrator, a sensible adjudicator will read the documents and go, well, look, I've got Mr. Smith in front of me, and she tells me that that a completely different story emerges from the documents, but the documents tell me something different. And that's very, very hard to overcome, and even harder to overcome as soon as you step outside England. Because as soon as you step outside England and you step into virtually any other culture, particularly civil law cultures like the Middle East, anything that emerges from Europe. If you've got a Swiss arbitrator, a German arbitrator, an Italian arbitrator, a French arbitrator, or anybody from a Sharia law background, if the documents tell story A and a witness turns up and tells story B, they're going to believe the documents. So you have to work out from the documents what happened. Use the witnesses to pull the documents together and to interpret the documents and guide the reader through the documents. But thinking you're going to win the case on the basis of a witness saying something completely different to the documents, it won't work. At the very top of that pyramid, kind of the point of the pyramid at the very top, the thing you see first and you hit first, but the least important in fact, is the delay expert who comes together and pulls all that together and puts it in a pretty picture. And the pretty pictures have a use, but that use can't be to invent the case and can't be to put the case together. That use can only be to graphically represent what in fact the documents and the witnesses say happened. Super important to realize that. And as soon as you get an expert, and you see it all the time, who presents a delay report that whenever you actually look at the documents, you can show just doesn't reflect reality, you're in big trouble. And if you think back over all the cases that sort of every 3 or 4 years, there's a case that hits the headlines. There was the John Lang case about the Building Gradation Hotel. There was that Walter Mackay case that I did. There are 4 or 5 other cases where every time people go, oh, something got really turned over in that case, it's always because an expert has turned up with an expert report that looks fantastic, and then documents have been shown to the expert and the thing falls apart. So it's really important to recognize the pyramid structure and to be realistic about whether your delay expert is graphically showing what in fact happened or whether she's inventing something. Now, concurrent delay. This is one of the greatest talking points, but unnecessarily so. Terminology is really important. Bear in mind what you're talking about, which is a situation where 2 or 3 things are happening on site at the same time, all of which, if you stand back and look at it and scratch your head, you think, well, I'm not sure which of these is in fact causing the delay here. And often 2 things can be happening at the same time, which are causing delays to different activities or to the same activity. So a typical example is you have to erect the steelwork in a particular bit of site, and that's a crucial bit of site. Comes 1st of April, whenever that site has to be worked on, and the employer can't give access to that bit of site, and in any event the steelwork's not there to be erected. Well, whose fault is it? And that's the sort of thing that turns on concurrent delay. One of the reasons it's so important is when you look at these extension of time clauses I've been talking about, there has been for years a debate about, well, what happens if there are two concurrent causes of delay, one of which is caused by the employer and one of which is caused by the contractor. And the kind of wisdom of Solomon that was arrived at in the Walter Lilly case, emerging from a case where it hadn't really been properly argued before that, is that if there's two concurrent causes of delay like that, one employer, one contractor, the contractor gets time, so it doesn't have to pay his liquidated damages, but doesn't get extra loss and expense on top. And for the last 20 or 30, well, 20 odd years, I think, people have sort of nodded along to that and gone, oh, okay, well, if that's the answer, that's the answer. As we'll come to look at in a second, I'm not sure that will remain the answer for very much longer. And the first time the Court of Appeal with Judge Coulson in it gets hold of this again, I think that'll stop being the answer. But that's the answer for now. And so the question that arises, well, what is concurrency? And in these notes, which Spencer West are going to send out after this seminar, I've set out all the various cases. And I'm not going to go through them all in the time, but I've set out the various cases and I've set out the bits from the cases. But the short point is this. The textbooks are full of different forms of words which effectively amount to saying two causes of delay are concurrent if they're both equally important or equally potent in causing delay. And people, in particular delay analysts, have for a long time, often when it suits their clients, and often I've put pressure on them to do so when it suits my client, interpreted that as meaning, well, it doesn't really matter when the things start or finish. If they're both happening at the same time and they both look equally important, that must mean they're equally potent, to use the words in the case. But that's not what the cases say. There's two streams of things going on here. There's all these cases happening in adjudication and arbitration where that argument's being run and arbitrators are going, oh, that sounds about right. And there's every single time it hits the High Court in England where that argument's run and the courts say, that's not right. That's not what concurrency means. Because all the cases, and as I say, I've got them all here and you can see them on the screen, finishing with the Saga Cruise cases, all say the same thing, which is that this isn't a touchy-feely exercise of squinting at it and going, well, are they both roughly as important? It's an utterly clinical logic exercise of saying, at the time two events happened, which in fact caused things to be delayed, and most often that is the thing that started first. So just to be absolutely clear about that, the point about that is, in my example, if we're turning up to put up the steelwork on April the 1st, and it gets to April the 1st, and it's apparent that two things have happened. Number one, the steelwork hasn't been delivered in time, it's not there to be put up. And number two, something has happened, which means the employer can't give access anyway. The cases say time and time again, you don't treat those, you don't just pretend those two things are of equal merit. You have to look and see what happened first. Because if in fact the steelwork was supposed to be there 3 weeks beforehand in order to be ready to be put up, and didn't arrive, so it just didn't matter whether or not access was given, then the lack of access just hasn't caused any delay. It was never going to have an impact because the steelwork wasn't there anyway. On the other hand, if a month before it becomes apparent that there's not going to be any access, then it doesn't matter if you find out 2 weeks after that that the steelwork's not going to arrive. The steelwork could never be put up anyway. So it's essential, whenever you're looking at concurrency, not to just view it as a touchy-feely, will they both look equally important. It's essential to sit down and say, of these two delaying things, what started first? There's a whole lot of different features to that, which are really interesting to take up a seminar on their own. It gives rise to people who realize this, hiding things, not revealing that the steelwork's not going to be there until after the employer says, oh, by the way, you haven't got access. It leads to employers not telling the contractor they're not going to have access until it becomes apparent that there's going to be no steelwork anyway. And you end up in all these reverse races. The other interesting feature of it, or at least I think quite interesting, is that the laws I'm describing is the law in England and Wales in these cases. As soon as you go to somewhere like the Dubai or Abu Dhabi or even Australia that deals with these things a bit differently, and I've done one or two cases there, saying to a judge it doesn't matter, this second thing didn't cause delay because the first thing started the day before it, will have the judges scratching their heads and going, well, that sounds rubbish to me. I'm not going to apply that sort of weird autistic-ish logic to it. Both things look to me to be equally important. So there's a real difference in how judges in England and Wales approach this, what the English law actually is, and how arbitrators in other countries look at it. And I think that's quite important. Kind of one of the last things I wanted just to talk to you about today before I hand over to Jennie about this is what I've described is what the law is in England and Wales at the minute in relation to normal extension of time clauses. But what happened in this North Midland against Cyden Homes case, which is a brilliant case, the Walter Mackay case, anybody who's read it will remember that it was a case about an exceptionally rich man who wished to have an exceptionally large house built and then fight about it forever or more. North Midland against Cyden Homes is exactly the same thing, only this house has got a lift for horses in it, which I think trumps the Walter Mackay house. It is a very big lift, and the lift for horses goes down to the basement where there's a swimming pool for horses. So that's a proper house. That's not like the house I'm sitting in. Anyway, in this house, the employer had the foresight to agree up front in terms of his contract what would happen if there was concurrent delay. And what he agreed is, if there's concurrent delay, you, the contractor, get neither time nor money. You get nothing. The contractor said, well, that doesn't sound right. We're not too keen on that as a proposition. That must be wrong. Went in front of Mr. Justice Fraser, who was then the head of the TCC, argued that, and Mr. Justice Fraser said, right, well, why is it wrong? They've agreed it, why is it wrong? And he said, well, it just seems wrong, it can't be right. Mr. Justice Fraser said, I've never quite heard an argument of it just seems wrong, it can't be right, so you lose. Then they went up to the Court of Appeal and did the same thing, and Coulson said, well, that can't be right, you lose as well. But what was absolutely apparent, and it's one of the things Justine was referring to earlier, is in argument in the Cyden Homes case, Lord Justice Coulson's starting point was, I don't know why everybody thinks that Walter Lilly's good law. It's just a first instance case, and nobody's ever really asked us, the Court of Appeal, what happens if there's concurrent delay and whether or not the contractor gets time and not money. And we don't think he does. We think all of that's up for grabs. And in comments outside court as well, in various lectures and stuff he's given, he said exactly the same thing, that if that question of whether concurrency gives you time but not money ever gets in front of the Court of Appeal, it's clear they're going to look at it again and not necessarily at all apply the Walter Lilly principles. So I think that's something to look out for. The last thing to say about this before I turn over to Jennie, I'm going to turn over the next slide to Jennie, is this proposition. I've told you that the Court of Appeal has said you can agree whatever you like in terms of concurrency. In particular, you can agree if there is concurrency, whether you get time and money or nothing. I think equally, and I think an argument in front of the Court of Appeal agreed with this. It was not in the judgment. Equally, there's nothing to stop parties agreeing in their contract what concurrency means. There's nothing to stop parties from saying, leave aside all these cases that Brannigan's bleating on about. Concurrency does just mean two things that happen at the same time where it would be unfair to not take them into account. And I'm slightly surprised more parties having done that. I've certainly seen some contracts now that I've been part of where parties are beginning to define what concurrency means and define what happens if there is concurrency. And I suspect we'll see more of that going forward, because it's got, I think, the Court of Appeal's approval stamped on it that this is what parties can do. So with that, I'll hand over to Jennie, and I will, if she tells me to move on the slides, I will move on the slides.
Fantastic. Thanks, Sean. Well, and building exactly on what Sean was just mentioning, it's in many ways a seminar in itself on what one might do. But we are in England and Wales out on a limb in terms of how concurrency is dealt with. And therefore, for those of you listening to this seminar this afternoon who are involved at the front end of negotiation of contracts, the place to go for ideas and some sort of stimulation in order to think how you can define concurrency and what sort of mechanism you might put in place. There's a plethora of it out there in other jurisdictions. And the paramount principle being that contract is king. You don't have to agree that things are going to, in concurrency is going to be dealt with in the way that the common law is dealing with it. If you have got two commercial parties negotiating at arm's length. And on the next couple of slides, we've just included some ideas of where you might want to go looking. I mean, FIDIC Yellow Book is already alive to this. And you can see in subclause 8.5, which we included on the slides, that there is an express recommendation that you can put something in the particulars conditions that define how concurrency might be organised. And in the UAE and all other civil jurisdictions and those relating to a code, the parties have always been free to allocate risk, and those concepts of extension of time and liquidated damages don't really apply. So there are many examples of FIDIC clauses that have been used in that regard. Sean, could you move on to Australia for me? Thank you. And the interesting experience that there has been in Australia, which in many ways we normally look at Australia as saying it's on a par with what is done in England and Wales, and we most of the construction law textbooks talk about the two alongside each other. Well, in Australia, it has to be remembered, because it's got a federal court system with 6 states, and the High Court is the equivalent of the Supreme Court, and you've got Supreme Courts below dealing with matters. There were, in the early 1990s, there were a whole host of inconsistent decisions dealing with concurrency on essentially many of the same facts, but because it was being dealt with across different federal states, different results were being received. So the Australian Standards General Conditions of Contract actually grappled with this principle much earlier than anybody in England and Wales had a mind to it. And you'll see that the various versions of the Australian General Conditions of Contract have got various different permutations of how to deal with it. There is no one size fits all within these. So in 1992 versions is very different from those in 97 and 2000. And you also, if you do some sleuthing on Google, you'll find there were also some published but not actually formally issued versions in 2015, so which go through exactly each different scenario you might want to use, all involving a superintendent. So if you are at front end and dealing with things, it's worth taking a look at what is already there to use. I'm very conscious that time is short, so I'm going to just move on a little bit to a few principles in relation to liquidated damages or liquidated and ascertained damages. Again, I'm going to keep it quite high level, even though many of you on the calls will know what this is dealing with. But going back again to first principles, which something that Sean was talking about in terms of delay. Damages are, or the purpose of an award of damages is to compensate an innocent party for loss or damage that's been suffered as a consequence of the other party's breach. And liquidated damages are no different in that. The only difference, the sole difference, is that instead of the actual loss or damage being investigated and quantified once those events have been known, with liquidated and ascertained damages, the clues being in the title, the parties are agreeing in advance what those losses should be. And they're commonplace in construction contracts, as we all know. Now, the thing about liquidated damages is it's inevitable that there is going to be a disparity between the employer's actual loss and the amount that ultimately is payable in liquidated damages. And that disparity can go in either direction. It can be that, you know, the contractor is getting away with paying less than actually the actual loss that's been suffered, although in reality, in most cases, it goes in the other direction. And so for decades, you know, what we were all dealing with in litigation and adjudication and arbitration was that contractors generally were tending to challenge those liquidated damages provisions on the basis of the level of those liquidated damages, the level at which they were chargeable, or the circumstances in which they were chargeable, amounted to a penalty, and therefore they weren't enforceable. And actually, the way everybody was arguing this was on the basis of a decision in 1915 of Lord Dunlop, when he referred to this, the concept of genuine pre-estimate of loss. So was the amount that was included in a contract actually a genuine pre-estimate, or was it an overinflated figure? So these sort of arguments were peddled out frequently, and as we've included on the slide, they were often raised, but they hardly ever worked. And the reason they didn't work was because judges didn't like to interfere with terms which had been negotiated between commercial parties. You know, it's that arm's length, contract is king provision all over again. The positions got even harder since Cavendish Square. That was a decision of the Supreme Court in 2015, where the court considered two separate provisions in two separate contracts. One was a commercial contract, and the second was a consumer contract. A case involved parking charges. And the court said there that the question wasn't whether it's a pre-estimate of loss, it's a question of whether the clause is penal. And inevitably, it's very, very rare that a clause will be found to be penal. So not so easy to argue now. And in fact, since 2015, I don't know what Sean's experience on this is, but I haven't seen a case hasn't come across my desk where a penalty argument is being argued whereas they were to a penny prior to that stage. If we could just move on to the next slide, Sean, that would be helpful. Thank you. Oh, can we go back? Yeah, great. Now, sorry, one forward, Sean. Brilliant. Liquidated damages are usually dealing with a situation where you've got a difference between the completion date of the project, which has been set in the contract, and the ultimate date when practical completion is certified. And it's, if you think about what it's designed to do, a contractor is seeking to establish, an employer is seeking to establish that the delay in the completion has caused them to suffer these quantifiable losses. But what happens where an employer has already terminated that contract? For instance, maybe the works are already so substantially in delay that the employer is tearing its hair out and has just got to the stage of saying, well, you know, that you're just not progressing these works and use the termination provisions that are available. And prior to 2019, there were three different ways that the courts were dealing with it. There was really, the law wasn't very settled at all, and judges were deciding things in different ways, largely because various different authorities weren't being cited to them when they were coming to their conclusions. There were three scenarios. One is that at termination, some judges were saying, well, liquidated damages provisions don't apply at all because you haven't got a delay to the end completion because it's just impossible to complete now. Some judges were saying, well, up until termination, liquidated damages apply, but after termination, they don't accrue. And the third scenario was that some were saying, well, liquidated damages do apply, and they carry on accruing until the replacement contractor has actually completed the works. And any of you will who do work with contractors or part of a contracting team will see the alarm bells ringing about that final scenario, because with a slow competitor contractor going on a job, you could be in the frame for substantial liquidated damages, but with no control. Triple point was an important decision. One, because it was the Court of Appeal grappled with this issue for the first time in a substantial period of time. Lord Justice Jackson, who, as many of you will remember, was the judge in charge of the TCC for a number of years, and then was the main Court of Appeal judge to be determining any construction matters. He gave the primary judgment in this and held essentially that in the standard provision where, and the JCT sort of scenario of having a completion date which is missed and then practical completion that is certified much later, then in those circumstances where there has been a termination of that contract and completion has been prevented, liquidated damages just don't accrue and are not recoverable. Importantly, that doesn't mean an employer has no right to recover damages. It just means that there is no right to recover liquidated damages. So it's still entirely open for an employer to be able to demonstrate that they have suffered loss and damage. That loss and damage might be greater than what they would have been entitled to under the liquidated damages provisions, but it just means that it's more legwork is involved in demonstrating those damages. And it's important to note that there's in a first instance decision, this Energo case, that says that it depends on your contract. So this isn't a hard and fast rule that means that all liquidated damages provisions now don't apply if you have a contract that's terminated. It depends on what the contract says, and it's only in those circumstances where the orthodoxy applies, where you've got the distinction between the completion date and the ultimate practical completion date. Okay, just very conscious of time. So let's move on to loss and expense. This is a little bit of a hobby horse of mine, this next slide, probably from my time in-house, and project directors who I sat with will probably be rolling their eyes as I go on at the same point again. Loss and expense claims, and any claims, and indeed the effective management of a contract is all about getting your ducks in order at a really early stage. Getting your ducks in order at an early stage doesn't mean you're gearing up for litigation. Often it means you're gearing up to have a more harmonious contract structure that actually is less likely to end up in litigation. I realize this is crazy for a barrister trying to persuade you to do this in a different way, but the key to all of this is really knowing what your contract says early doors. And in an ideal world, and we know this never happens, but in an ideal world, you have a project where you have a contract that is negotiated and executed before works commence on site. We know that that never happens. Just because that doesn't happen doesn't mean that there doesn't need to be an effective review process that's going on at all times at an early stage to make sure that what is happening on site dovetails with what is being negotiated by your commercial and legal teams. And what one often finds is that you have contract procedures being implemented on site, which are simply based on what the project teams always like to do. And they do not marry well with what is being negotiated and ultimately is signed off by the commercial teams. So what I would say and implore project teams to do is at a really early stage, sit down and review where you are in terms of your contractual structures. If they are still in negotiated stages, still review that and check what your provisions are in relation to payment, notices, design approval, dispute procedures, what relevant are going to entitle you to an extension of time, because they are not all the same. There are many boilerplates, but the number of times that Sean and I and our other colleagues will come across situations where your contract actually says one thing has to be done in terms of providing notice, for instance, and something very different is actually being implemented by project teams. It happens time and time again. And when you do get to a stage where you have an executed contract, you may have been working on site for 2 years and it's a week before the date for completion and the contract is signed at that stage. It's still not too late to have to review those procedures, because one thing you need to check is that what you have been implementing on site matches what has ultimately been agreed. And if it doesn't ultimately marry up, then you need to have a paper trail showing you discussing that with your equivalent number in the employer's team. Say, well, this has been agreed, but we've been implementing this system before. Either we agree as a variation, we carry on implementing that system, or we are going to alter the system. And the reason I say this is not really just in relation to litigation is the concept about project harmony. There are so many situations on site where you might hear an employer say, oh crikey, the contractor's gone all contractual on us. And that statement is usually triggered by the fact there's been a change in attitude from what was being implemented when you were in the honeymoon period, and what ultimately begins to happen when things are becoming more acrimonious. If you have a procedure in place that is firm and fair from the outset, you don't have this Belisha beacon to the things getting a little bit acrimonious, and you've got more cover for much longer periods. So keep it firm and fair from the start, keep it contractual in accordance with what is either being negotiated or has been agreed, and you won't suddenly have this spike when something goes wrong on site and you're beginning to think about the parting of the ways, and that makes it all much more effective. Right, that's my little lecture over. Just finally, just dealing with loss and expense in terms of how to go about making a claim. One thing to remember is that your loss and expense claim needs to correlate with the time when you actually have suffered delay. It's all too easy to look at a period and it's a tag along bit at the end of a contract, but actually that's not where your costs are arising. Your time when you're spending the most amount of money is when you have that delay. It's not at the tail end of the job when you're off hiring plant and you haven't got as many personnel on site. And recognizing that your loss and expense claim must relate to the actual period of delay does influence how you should be preparing for it. And in relation to this, there's two things to remember. The first is that front loading of claims preparation is absolutely key. If you are in a period of delay, assigning staff to actually assist in that, internal staff to assist in collation of documentation at the very point when the delay is occurring, will pay dividends later on. And this is going back to the same point that Sean was saying about the pyramid claim structure. Again, you need that base layer of documentation to be in order to be able to build up a loss and expense claim. It doesn't, you can't go back and counterfactually fill that in. Actually, what you need to have is the raw data to start with. And so if you have someone on site who is internal, again, it's not a Belisha beacon to the fact you have got somebody in doing this work. You've got somebody internal collating it. And the second point is that person is collating it for the external QS, who, as we've included on the slide, a good quantum can really repay themselves their worth in terms of their involvement at an early stage. Use a QS to show you what you actually need to be collating in terms of your information for that period. Don't leave it until half a year down the line when you're trying to formulate an adjudication. You need to do that legwork early on. And just leading onto the final claim, so we've got time for questions. A word about the court's approach. The court's approach to evidence on loss and expense claims, and generally in terms of quantification, can basically be summed up as common sense. In terms of when it comes to looking at proving loss and expense, and it was quite key in Walter Lilly, that where a contractor is find themselves in a situation which is not their fault, the provisions of a contract will not be construed really harshly against them so as to require proof to the nth degree. I mean, the words of the judge in that case were that clauses should be construed in a sensible and commercial way that will resonate with commercial parties in the real world. And actually that's been proven. There's this recent case of Premier Engineering against MW High-Tech. This is a case that involves absolutely no law whatsoever. It was issued last week, I think, and it involves an absolute forensic examination of timesheets and turnstile data on site. Many of us will have encountered this sort of scenario, but here there were basically allegations that the turnstile data and the timesheets were manufactured and they were not an accurate reflection of the amount of manpower that was on site. But yet again, and that's not a case involving loss and expense, but it's showing how the TCC generally will approach that question of proof and whether it's enough. And even there, where there were cases where they'd had people in the box being cross-examined, and they had shown them parts of those timesheets that had been countersigned a week before they were actually the dates that they related to, even with some areas where there were clear question marks as to how much evidential weight they should have, the court has still approached it in a very, not broad brush, but certainly a commonsensical way, and not required proof to the nth degree. So there's an element of latitude, but if you are preparing your claim material much earlier, that you have got less scope for being criticised in that regard, because it is contemporaneous. I'm conscious that it is 10 to 5. We've whistled through that, and we should probably now open the floor to questions of things that you actually really want to know about.
Thanks very much, Jenny and Sean. Yeah, there have been a couple of questions that have come in on the chat facility. The first one, is there a requirement for a contractor to undertake a variation in a reasonable time or regularly and diligently? And if so, who decides how long this time is?
The short point is yes, there is. And if, in terms of who decides, the person who would first decide would be the contract administrator. In some contracts, that's the engineer. In other contracts, that's the architect. But whoever has to sit down and work out what extensions of time should be given, and so on. So the way it would work is, if a variation is issued, that is in almost every contract going to be a relevant event that would entitle the contractor to an extension of time. The contractor would ask for his extension of time, and the contract administrator would have to work out whether the time the contractor was saying was needed to do that was more or less than was reasonable. And that contract administrator would then make the decision. If one or other party disagreed with that decision, then it would go through the dispute resolution process that the parties had decided. So ultimately, it would probably go to adjudication, and many of the adjudicators on the call will have spent half their lives working out whether any particular variation should have taken more or less time than the contractor says it did. And if adjudication doesn't solve it, then it would end up in arbitration or litigation with the arbitrator or judge making that decision.
Okay.
So that's my answer.
Hopefully that's answered the question there. Okay, next question. If an employer-caused event starts first and finishes last, such that it would be reasonable to conclude that the employer-caused event is critical, and there is an event for which the contractor is responsible within the period of employer-caused delay, I've got two questions. Is this a concurrent delay? And secondly, should the contractor be deprived from its time-related costs for the period of its delay?
Right, so I know who this is from. This is from Rob Pallas-Clark, because he and I talk about this all the time, so he set me up with an easy question. Thank you very much, Rob. Thought so. What we've got to remember is, when we're talking about these extensions of time or so on, we're talking about extensions of time to the works as a whole, and the costs which are associated for the whole of the works being extended. That is to be distinguished from individual bits of cost which are associated with particular activities being extended. So you can easily have a situation where an employer does something which means that a particular bit of the works takes much longer, but that doesn't in fact have a knock-on effect to the delay to the works as a whole, because some other bit of the works has taken even longer. In that situation, you would not have an extension of time for those works, but you would be able to charge, subject to whatever the contract terms say about it. If it's an employer-caused problem, you should be able to charge for the costs of that activity being extended. So let me use an obvious example. Let's say you have a big old site in which you have some groundworks going on one bit of the site, while the superstructure work's going on another bit of the site. And the superstructure works in one bit of the site are delayed, but it doesn't really matter because the groundworks in another bit of the site are delayed so much that the critical path of the works goes through all of that. In that situation, you should be able to get your costs, which are, if you're a contractor, your costs of your superstructure works being delayed even though they don't cause critical delay. So there's a distinction to be made between the costs of individual activities which are delayed or disrupted and the costs of the site overall. And so even if you've got an event which is not a critical cause of delay, it may cause delay to some of the activities and money might flow from that. So it's the answer to Rob's two questions are, in the scenario he's just described, of the employer caused delay starting before the contractor delay and finishing after it, it is extremely unlikely the contractor delay will cause critical delay to the work as a whole. But it may well be that the employer is able to say, well, the damage which has been caused by me lengthening the period of delay can't include any monies for those works, because what in fact has caused the cost of those works to increase is not my delays to the thing as a whole, but your own delays within that. And that, for big projects where you have a lot of contractors doing individual activities which are each of them very expensive, can make a big difference in some cases. And people again lose sight of that. So you always have to bear in mind, what are the costs associated with the works as a whole extending? And within that, are there buckets of costs which are not caused by the whole works extending, but only caused by individual activities going on for longer? And you should be having a battle about each of those buckets of costs, in addition to a battle about the overall costs of the project going on for longer.
Okay, thank you. Next question. Could you briefly explain the difference between loss and expense claims and disruption claims? Can a disruption claim succeed in the absence of delay?
Jenny?
Well, loss and expense claims are more tangible things, whereas disruption is your kind of prolongation costs of being on site for longer, whereas your loss and expense is much more defined silo of certainly it's been something that's been caused by a certain event. I think is the short answer to that.
I think that's, Jenny's 100% right. There's also a deeply practical point here, and it's this. And you don't realize it until you sit as an arbitrator yourself, but all the adjudicators will know it, so they're on the call. As soon as you sit as an arbitrator, as soon as you see a disruption claim, you automatically assume it's worth a maximum of half of what is pleaded. And very often it's worth approximately a third of what is pleaded. And so what you really, really want to do when you're working out what goes into your claims is to put as little of the money you're claiming into the bucket marked disruption as humanly possible. So you want to, if something happens which causes the works to be disrupted, you do everything you can, in my view, to show that those monies are monies that should be part of the valuation of a variation, or monies which are time related because the thing went on longer, or monies or monies which are just loss and expense, because all of those are viewed as the bright-eyed and bushy-tailed cousins of the runt of the litter, which is the disruption claim. So really, if you're doing your job properly, your disruption claim should be literally all the stuff that you can't really fit in under the variation label or the loss and expense label, or things which are attached to specific events happening, which are just damages for specific things happening. So that's another kind of practical distinction between the two. One is viewed in much better odor than the other when it comes to people deciding these claims.
Great, thank you very much. Okay, another question. There is a delay in progress. We're capturing evidence and costs at the time. Should we issue these to the employer weekly or monthly or later in the project? What's your guidance on this?
I'll let Jenny give her answer on that, and then I'll step in, because she's going to have the moral and good answer from working in-house, and I'm going to have probably the much less moral answer. So far away, Jenny.
I don't know if that's right, actually, Sean. I think we might be the same. It depends whether you really have to show, because I don't think you necessarily knew that providing the evidence, unless there's a real cause for it and there's a requirement under the contract to do so, you need to be very careful about doing so in the right way. So if there is a provision that is requiring you to and obviously many of the JCTs have this, where you actually have to demonstrate what is being requested and the reasonable request of the employer, and the employer is saying to you, well, you know, we're going to be trying to value these as we go, then it would be incredibly difficult to withhold and not provide. But it's, from my perspective, it's much more about making sure you have kept the records you have, so you can use your arsenal when you need them in the proper way.
So I think it depends on how rubbish the other side are. Because if they're truly rubbish and out of their depth, then you do want to provide it every week so they don't comment on it. And so you can say to the likes of a sensible adjudicator, well, you have to trust my information because I give it to them every week and there wasn't a squeak out of them saying it was wrong. If, on the other hand, they're going to question all that information and provide counter information of their own and show your information that you're collecting as you go along is wrong, you don't want to give it to them unless you absolutely have to, because you want to wait till the end and say, look, we've kept all this information contemporaneously and they have none. So that's my rather more immoral view of it. To some extent, and I'm not slagging off the questioner, it's an old-fashioned question, because of course modern contracts, and Jenny's 100% right about this, will very often have procedures in place to share information up front, or to even agree information up front. So all the NEC contracts and so on, you just can't hold everything up your sleeve, because if it's a compensation event that emerges, you have to say, look, this is what's happening, and so on. So I think Jenny is ultimately completely right that it depends on what the contract says about it. If the contract is silent about it, then I think you have to gauge what strategically is better for you, given that what you're trying to achieve is have a suite of information at the end that's going to be accepted by somebody. Is it better to supply it at the time, or hold it up your sleeve and then supply it? And that all depends on what reaction the other side are going to have to it. That's my view.
A couple more questions. Have you got time to take those, Sean and Jenny, before we end?
Yeah.
I have.
Yeah, that's fine.
Yeah.
Okay, so these will just be the last two questions. So to what extent, and I think this is sort of linked to the last question, to what extent does the project manager, contract administrator, employer's agent, etc., have to assess a claim when it's poorly substantiated?
Again, it's a question of it depends, because you've got a situation where if you haven't reached that kind of burden of proof, and that you haven't produced enough, then it's quite proper for an employer's agent to say they can't assess. And the majority of contracts say something similar on that. It's an objective assessment, isn't it? It has to be carried out to be assessed on a case-by-case basis.
I can't improve on that answer.
Great. Okay, last question. Do you have to wait for the full extent of delay to award an extension of time? If not, can you award a second extension of time for the same relevant event?
Well, Jenny did the last one. Why don't I do this one? That really does depend on the terms of the contract, and you have to be super careful about this. Generally, most contract terms work out by saying that the employer should look at the extension of time and should give an extension of time once and once only. They don't expressly say that, but that's the effect of the terms. And that can be really quite difficult when the employer has to do it on a prospective basis. But generally it's once and once only. But you can have some contracts I have seen, particularly for really big projects where there's lots of interlocking parts, which expressly say that the extension of time can be revisited, and very often they say revisited and increased but not decreased. But I think it is more common that the contract administrator the clause effectively says they will consider a relevant event and give an extension of time. It doesn't give them power to go back and do that again. But it really does depend on your contract.
Well, I'd like to thank Sean and Jennie for taking up the time this afternoon to give this seminar. I hope that you've all found it useful. If you do have any further questions, then do drop me a line, or I'm sure Sean or Jennie would be happy to speak to you. So without further ado, I'll bring this to an end. Thanks very much. Thank you.
Thank you very much, Justine. Thank you, Spencer West. Much appreciated.
Thank you all.